All right, so let's just start the session. Good afternoon, all. Welcome to the special parallel sessions of the Symposium on Social Science 2020 A2 on Legal Development in Indonesia, Energy, Infrastructure, and Migrant Workers. This is a special panel organized by the Faculty of Law, Universitas Gadjah Mada. The panel discusses on the legal aspect of the development of electric vehicle, LNG infrastructure, the one price oil policy, and the remittance from migrant workers with a practical focus on Indonesia. The panelists will be addressing the current policy challenges and how to improve them in the future. There will be four presentations with five presenters today. The first one is Dr. Mailinda Eka Yuniza. She will be presenting on the One Price Oil Policy Program for meeting the needs of fuel oil or BBM in Indonesia. The second presenter will be Melodia Puji Inggarwati, and she will present on liquefied natural gas or LNG infrastructure development policy for fulfilling electricity needs in Indonesia. The third presenter will be Iwayan Bayu Eka Pratama and Rahma Chandrika Ramadaniati, and they will present on the development of electric vehicle in Indonesia, the certain doubts from the governments towards the incentive policy. And the four presentations will be Anissa Ayuning Tias, and she will present on the role of the Indonesian government in managing the remittance of Indonesian migrant worker. Each of the presentations will be given around 15 minutes to present their paper. And then after all of the presentations, we will have 30 to 40 minutes to discuss. All the participants may give questions live or by text on the chat box. So without further ado, let's just start with the first speaker, Dr. Mailinda Eka Yuniza. Time is yours for 15 minutes, please.
Okay, thank you very much, Arum. I'm trying to share my presentation here. Um, okay, okay. Um, so can you see it in your
Yes.
computer and your laptop? Okay. So, Assalamualaikum warahmatullahi wabarakatuh. Good morning. First of all, thank you very much for all of the organizing committee of SLSS who has given me the opportunity to share my research in these sessions. So, without the longer ado, I want to share my research about one price policy for fuel oil BBM in Indonesia. Yes. So when we talk about one oil price policy, I think you are very familiar with this issue because I believe that all of the audiences here have already heard about this policy previously. Yes, the policy that I will talk about is a policy issued by the Jokowi government to uniforming the official selling price of oil of fuel all over Indonesia. One of the reasons why this is like becoming important to by the government to issue this policy is because there is a huge gap of oil pricing all over Indonesia before the implementation of this policy. In 2009, for example, in Papua, the price of gasoline could reach like 70,000 to 100,000 rupiahs, while like in the other regions it's less than that. Particularly in Java, the price is less than like 10,000 rupiah. The same condition happens also in treaty regions, daerah terluar, terdepan, dan tertinggal, or the outermost frontier and disadvantaged regions. So because of that, in 2016, the government enacted one oil price policy in Presidential Regulation number 191 of 2014 concerning the supply, distribution, and retail selling price of oil fuel as amended by Presidential Regulation number 43 of 2018. The main objective of the implementing the one price fuel policy or in all parts of Indonesia uh, is to encourage better development, particularly in the treaty regions. So in 2019, there were already like 170 existing distributors, and the government targeted like in 2000 to 2024, we have like 500 points of the distributors. So the research questions in this presentation are: first, how is the implementation of the one price oil policy program in Indonesia? And then what are the challenges faced by the government in implementing the policy? And then the third is, how are the proposed solutions to solve the existing challenges? Method used in this research is normative empiricals. So I do both like the normative approach by study documents and also the empirical approach. I did like case studies on elephant regencies Indonesia. So we visited elephant regencies in Indonesia. Uh, we met the distributors and also the local government and doing like interview with them and also the related stakeholders. The 11 regencies are Mentawai Island Regency, West Nias Regency, Sumeneb Regency in East Java Province, and then Kapuas Hulu Regency, Berau, Regency Seruyan, Belu, Sumbawa, Tojo Una-Una, West Seram, and South Serang Regency. So these regencies represent like treaty regions in Indonesia. And then the implementation, the first questions, the implementation of one fuel price policy. So the government under the Ministry of Energy and Mineral Resources and BPH Migas has made its best effort to implement the one fuel price policy program. So in 2017, they targeted to build like 55 distributors, and they can reach that target by establishing 45 distributors in the area with good land infrastructures and good sea infrastructures. In 2018, they established like 67 distributors. In 2019, 39 distributors. So uh, in total, in 2019, we have 170 distributors from the target 500 distributors in 2024. Uh, if we look at the legal framework, Indonesian government use distributors, the term not gestation or oil commerce as its legal nomenclatures. Distribution is one of the activities that come under the downstream business activities. In downstream business activities, it's carried out by business entities that already have a business license, is issued by the ministry. We call it as Badan Usaha Pemegang Izin Usaha Niaga Umum, and are organized through a fair, healthy, and transparent business competition mechanisms. So the Badan Usaha, the business entities in distributing fuel, oil, and gas, they are not like directly doing it by themselves. Usually, they ask like distributors appointed by the business entity through selections. Um, and we have the Ministry Regulation number 36 2016, which assigned BPH Migas to focus on the One Price Fuel program. The BPH Migas is assigned the task of giving new assignment to assign business entities to provide and distribute at certain locations, as well as to arrange, supervise, and verify the smoothness and accuracy of the distribution of the specific fuel. The distribution of these specific fuels throughout Indonesia are carried out by business entities that receive assignment through the distributors appointed by the business entity. In the event that there is no distributor at certain location, the business entity concerned must appoint a new distributor. So there is a decree issued by the Director General of Oil and Gas, which sets specific location in 148 district for distribution of the specific fuel in Indonesia. So the government, they implement the one price fuel program by establishing a new distributor, particularly in the treaty regions. However, in doing that, there are challenges faced by the government. The first one is related to conditions or requirements that has to be made by the distributors. These conditions actually regulated by uh, regulated in Minister of Energy and Mineral Resources Regulation number 16 2011, and then it was later revoked by the newer regulations, which is regulation number 13 2000, Minister Regulation number 13 2018. There are like several conditions stated in the previous law, but then this requirement is trying to be simplified in the law number 13 2018. However, the Minister Regulation number 13 2018 does mention additional requirements which is not yet existing in the previous one. For example, the deed of establishment, company registration certificate, distributor taxpayer identification number, and also location permit. The location permit, for example, it issued by the district government of the city government related to the location of the facilities. Nah, these conditions are or these requirements then interpreted differently by regional government. So this is one of the problems. So one of the province, for example, require less permits compared to the other province. And the other problems, apart from licensing, the field research shows that there are problems related to the existence of retailers or sellers other than the official distributors agencies. This is what I've discussed previously regarding the conditions stated in law number 16 2011, and then this is the additional requirements stated in law ministerial regulation number 13 2018. uh, so this is the different interpretations done by province in Indonesia. So for example, in the Mentawai Islands, they require 10 permits. It's more than in West Nias, which require 7 permits. In Sumenep, they only require 6 permits, and in Kapuas Hulu, they only require like 4 permits. So usually more permits mean longer time and also more expensive. This is one of the problems faced by the government in applicating the one oil price policy. So the third question, the proposed solutions. The first one, it is necessary to initiate a joint discussion between the regional government, the Director General of Oil and Gas, and also BPH Migas to see and evaluate existing regional permits to encourage uniformity and certainty. Permits which is now existing and also recommendations. Actually, there are like which is not longer valid permit but still exists. It should be removed from the list of permit that must be fulfilled by the distributors. Second, the implementation of OSS or one single submission should be encouraged. Apart from applying for permits online, it is also necessary to encourage a joint forum between existing agencies that can encourage faster licensing, for example, related to environmental permits. And then the last solution, proposed solution, is there is a need for more supervisions by BPH Migas related to the distribution of the fuel, especially because there are still many incidents that the subsidized fuel is purchased for resale by retailers. The conclusions, the government has done a lot of permit simplifications, particularly after the issuance of the new ministerial regulations to support the establishment of distributors for the implementation of the one price policy program. Furthermore, the government has also issued government regulation number 24 2018 concerning electronic integrated business permit services, including a permit for the establishment of distributor so that the permits could be accessed online through OSS institution. However, in practice, there are still some obstacles in the establishment of the distributors, particularly related to the different interpretations between one provinces to the other provinces regarding the ministerial regulation, and also the existence of illegal sellers which buy like subsidized oil from the government and then sell it with the higher price. So this is the end of the my presentations. Thank you very much. I giving the back to the moderator. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Um, Thank you, Ibu Mailinda, for the presentations. I know some of you already have questions to be delivered to the first presenter, and you can start to type your questions in the text box on Zoom, or if you are on YouTube, you can also start to raise the questions on the live chat or the comment. We will have the questions of the presenters after all of the presenters already present their PowerPoints. So for now, let's just start to um, hear from the second presenter, Melodia Puji Inggarwati. Time is yours for 15 minutes, please.
Thanks for the time given to me. So I will share my presentation first. Okay. Good afternoon, everyone. Let me introduce myself. My name is Melodia Wijgarwati as representative of the authors. And today I would like to deliver a presentation of our team, Dr. Malinda Ekayuniza and Muhammad Jibril, with the title of Liquefied Natural Gas or LNG Infrastructure Development Policy for Fulfilling Electricity Demand in Indonesia. Here is the outline of the presentation. James E. Anderson, the public policy expert, said that policy is a purposive course of action followed by actors or set of actors in dealing with problem or matter concern. And then based on this, policy is a means of achieving goals. To achieving goals, actors are needed to implement the policy. Policies must be implemented, and Gridell said that implementation is a general process of administration action that can be investigated at a specific program level. LNG infrastructure development policy is one of substantive policies, that is, policies on what the government will or want to do. The emphasis lies on the subject matter. And policy statements submitted by the government require certain means to be implemented. The main activities that are important in policy implementation are organization, interpretation, and implementation. Organization means the creation or reordering of resources, units, and methods to make program work. Interpretation means interpreting the program so that it becomes a plan and direction that is appropriate and acceptable and implemented. And application means the routine requirement of payment or other services tailored to the objective or program equipment. With the existence of a policy, there must be a means of supporting the policy, namely was laws and regulations. Tati Mariati, by her article entitled Public Policy Implementation Strategy in Encouraging Acceleration of Internet Use Development, said that policy required confirmation in the form of laws and regulations. Sudikno Martokusumo said that laws are used to achieve goals. Therefore, government policy poured in a legal product in the form of state regulations or state rulings, which is one of part of the law. According to Igede Panja Astawa, state regulation or state rulings or decision in a broad sense can be divided into three groups, namely laws and regulation, delayed regulations or policy regulation, and basicing. Policy action is carried out by actors who are determined by the government to implement policies. One of the government policies related to the fulfillment of electrical demand at the time is government policy of 35,000 megawatt of electricity. LNG, as a type of natural gas that is used for the provision of power plant, is a cheap, safe, and environmentally friendly energy source. The potential for gas reserve in the country is greater than petroleum. Economic Policy Package 9 issued infrastructure development that is acceleration of electricity infrastructure development. The policy is implemented through 1. Issuance of a presidential regulation on electricity infrastructure. In Presidential Regulation number 4 of 2016 concerning the acceleration of electricity infrastructure development. 2. Funding in the form of state investment. And 3. Renewable energy development for resolution of special conflicts and other legal issues. And 5. Establishment of a separate business entity in supply of electricity. Policy of fulfilling electricity demand through LNG port in the provision of the legislation, such as Regulation of the Ministry of Energy and Mineral Resources number 45 of 2018 concerning the use of natural gas for electric power, and Decree of the Ministry of Energy and Mineral Resources number 1750 of 2017 concerning the determination of the location and utilization of natural gas for the provision of electricity by PT PLN. Research questions from this paper are: 1. How is the government policy in fulfilling electrical demand in Indonesia today? And 2. How are LNG infrastructure development policies in fulfilling electrical demand in Indonesia, and what kind of regulation can support these policies? Ladies and gentlemen, LNG is a type of natural gas that can be used as a power plant, namely gas power plant or in Indonesia mean PLTG, and steam power plant in Indonesia mean PLTU. As a cheaper energy source and has large gas reserve in Indonesia, LNG is the right choice to be used as a power plant to meet today's national electricity demand. LNG is environmentally friendly compared to petroleum. The use of LNG in electricity supply can also contribute to emission reduction, which is a program in the Paris Agreement. The demand of natural gas as clean energy continues to grow in addition to the program for the conversion of fuel oil to gas fuel, which is continuously being promoted and effort to achieve Indonesia's energy mix, namely natural gas, by 2025 by 30%. And as explained in the background before, government policy in fulfilling electrical demand in Indonesia is outlined in Economic Policy Package 9 about acceleration of electricity infrastructure development. Government's policy in fulfilling electrical demand in Indonesia divided into planning policies and implementation policy. Planning policy is a policies that regarding target for meeting electricity needs and how to achieve this target, which poured in Presidential Decree number 18 of 2020 concerning the National Medium-Term Development Plan 2020 to 2024. Appendix 2 of Presidential Decree number 18 of 2020 state that is related to national strategic project in the electricity sector, namely 27,000 megawatt power plant, 19,000 circuit per kilometers, and 38,000 megavolt ampere substation. Based on the medium-term development plan above, there are no specific provisions stating how much LNG is needed to meet certain electricity demand. However, the amount achieved for the electricity capacity of each gas-fired power plant has been included in the Ministerial Decree of Energy and Mineral Resources. And based on the sixth dictum of the Decree of the Minister of Energy and Mineral Resources number 39, 2019 concerning ratification electricity supply business plan for PT PLN for 2019 to 2028, it is stated that to encourage carbon emission reduction and increase in domestic use of natural gas, additional power plants sourced from natural gas can be added with a capacity up to 10 megawatts. And in fulfilling target for 10 megawatt electricity from LNG, the construction of power plant infrastructure is required for 1. The LNG production infrastructure, and 2. The supply of electricity from LNG. and PT Pertamina and PT PLN assigned to carry out the supply and development of LNG infrastructure and the supply of electricity. The LNG infrastructure development policy is stipulated in the Minister of Energy and Mineral Resources number 13 2020 concerning the assignment of the implementation of supply and development of LNG infrastructure and conversion of use of fuel with LNG in the provision of electricity which was stipulated by the Minister of Energy and Mineral Resources in March 2020. Based on the policy of fulfilling electrical energy in Indonesia, a regulation is needed to support the development of LNG infrastructure as a source of energy for power generation or electricity infrastructure development. Technically, the electricity license mechanism can be done through online single submission or OSS and complete through one central one-stop service or Indonesian means PTSP, and this is regulated in the regulation on the Minister of Energy and Mineral Resources number 39 of 2019 concerning electronically integrated business licensing services in electricity sectors. And based on Article 5 of the Minister of Energy and Mineral Resources number 39 of 2019, the electricity supply business license consists of electricity generation, electricity transmission, electricity distribution, and electricity sales or integrated. Based on regulation of the Minister of Energy and Mineral Resources number 39 of 2019, the construction of a power plant requires a license so that it requires the roles of ministries, agencies, as well as regional heads. And there are licenses for electricity supply companies and investors. Power plant construction licensing requires the role of both the minister and the regional head. For example, the governor's recommendation in the application document for determination of the business area. And then the authority to grant permits and non-licensing related to the acceleration of the implementation of electricity infrastructure development is delegated to the head of the One-Stop Integrated Services and Investment Agency, or in Indonesia mean BPTSP. So a regulation is needed to support the development of LNG infrastructure as a source of energy for power generation or electricity infrastructure development. The existing legal framework of fulfillment of electricity needs through the LNGR, regulation of the Minister of Energy and Mineral Resources number 45 of 2018 concerning utilization of natural gas for electric power, and decree of the Minister of Energy and Mineral Resources number 7050 2017 concerning stipulation of location and utilization of natural gas for provision of electricity by PT PLN. In the future, legal framework is also a recommendation in this presentation. Supporting laws and regulation of LNG infrastructure development for fulfilling electricity needs in Indonesia are: 1. The establishment of regional head regulations to regulate electricity-related business licensing, and establishment of ministerial regulations and important agencies or institutions in order to synergize the mechanism for developing LNG infrastructure for electricity supply in Indonesia. This is the presentation I have delivered. I apologize for all the lack of it. Thank you for your attention and good afternoon.
Good afternoon. Thank you, Melodia. And of course, if you have questions for Melodia, you can start to type your questions in the chat box or in the comment on the YouTube, and I'll give you time at the end of the presentations to have 30 to 40 minutes to have a question and answer sessions. For now, let's move to the third presentation. It will be given by Iwayan Bayu Eka Pratama and Rahmah Cantika Rama Daniati. 15 minutes time for you. Please start now.
Okay, thank you, Mbak Arum, for the time. I will show my presentation. Okay, it's already shows, right? Okay. Good afternoon, the participant in this meeting room. Allow us to introduce ourselves. My name is Wayan Bayu Eka Pratama and my friend Rahma Chandrika. We will present our study entitled The Development of Electric Vehicle in Indonesia, the certain dubs from the government toward the incentive policy. And we will present it into the six part, our introduction, literature review, research method, our findings, and the conclusion. Let me start by giving you some background about the environmental issue. The existing environmental data shows that the transportation sector is the fastest growing sources of greenhouse gas emission by 71% since 1990. And Indonesia is one of the 10 countries that produce more than 68% of global greenhouse emission. And it is because the automotive sector, which is one of the big industries in Indonesia. Now, the automotive sector reached 1.07 million vehicles with sales growth of 4.9% per year. But lately, global energy trend is switched to the use of renewable energy, especially to the electric energy. With this trend, the dependence on the fossil energy can be reduced. Electric vehicle often regarded as a zero emission vehicle, and it is widely seen as a final solution to the greenhouse gas emission problem. It is also the main justification why Indonesia needs to apply electric vehicle program. Okay, talking about the electric vehicle program in Indonesia, the Indonesian Ministry of Industry said that Indonesia has a great potential to develop battery-based electric vehicle, or we know it as the BEV program, battery-based electrical vehicle. As well, they're targeting national production to begin in 2022, and by 2025, the sale of electric vehicle, battery-based electric vehicle, reached 20% of total cars production. The Indonesian government has also to provide incentive for accelerating the development or BEV program. But unfortunately, the development of electric vehicle in Indonesia is lower than the other state. It is suspected by a number of problems such as a low purchasing power of the community, the BEV unit price is relatively high, and increasing reliance of conventional vehicle. There is no public infrastructure that enough to support the government policy. And if we comparing the target in 2025 and the schematic problem, the big question is, can Indonesia achieve its target if the problem still exists? So we will discuss two research questions. First, what are the problem issues and incentive policy that used in the development of electric vehicle in Indonesia, and how is the readiness of infrastructure for electric vehicle in Indonesia? Okay, in this study we use two literature review study by Aziz and Sidabutar, and taking into account the concept both by Aziz and Sidabutar, this paper aims to fill in the void of both studies and focus toward the legal implication of BEV incentive policy. Next, our research method. This research use normative legal research method. The data used are secondary data, and then we analyze based on statutory approach regarding to the related law, electric vehicle law. Okay, our result first, we have to know the legal mapping of incentive policy in Indonesian law framework. The law number 30, 2007 concerning energy is allowed that from all energy supply and utilization, including the renewable energy. From this law, two government regulations were issued. First, the government regulation on national energy policy and the government regulation on energy conservation. All of them is provide an incentive provision and in their respective field. But then on 2019, another derivative regulation was issued, the President Regulation number 55, 2019. It is specifically regulates the BEV program for road transportation. This regulation provides direction for accelerating BEV by using an incentive giving scheme. Interestingly, incentives are the most highlighted topic by media because they are considered to be a trigger mechanism for the development of the BEV itself. But here's the problem. We found three main problems that causing hardness to the BEV ecosystem in Indonesia. First, the lack of incentive for consumer. If we detail the list of incentives in the Article 17, paragraph 3, the President regulation these incentives are aimed at three main groups. First, the company, research institution, and the consumer. From 17 list of incentive, company have the potential to get a big number of incentive, 13 lists of incentive. Meanwhile, for consumer, just only 4 lists of incentive. This means that the convenience for consumer is fairly small, whereas consumer are the main point in creating a new market related to the BEV. Besides that, there are no cutting price or subsidized vehicle price in the BEV incentive. In fact, the price of one BEV unit is relatively high when we compare to the conventional one. The policy of cutting or subsidizing price has been implemented in various countries like China, Germany, and Sweden, and it is becoming a central policy that they carried out. We think that the government focus on production is important, but creating the whole market is more important. And how will it be when the production is massive, but the people purchasing power will still remains low? The problem number two, the government does not control the use of conventional vehicle. President regulation about the beef is to focus on the beef itself, while the restriction on the conventional vehicle are slightly regulated. Article 16 of the BEV presidential regulation has regulated the control of the conventional vehicle, but it is not explained in detail how the control will be carried out. Consumer must have the reason to switch to the BEV conventional uh, vehicle have becoming because conventional vehicle have becoming a convenience for Indonesian today. The government must form a policy that imposes restriction on the use of conventional vehicle. One of them by providing a disincentive policy. In fact, the provision of this incentive policy is one of the strategies that's stipulated on the government regulation on energy conservation. And this incentive is intended for user of energy sources who do not implement the energy conservation. This incentive, for example, like whiten warning, revocation of business license, and the reduction of the oil station (SPBU). This scheme also be adopted in the BEV regulation. Thus, combination from the incentive and the disincentive hopes to stimulate willingness from user to switch to the beef. The third problem is the provision on the BEV program is still require more technical regulation. Some of incentive of BEV presidential regulation is still require more derivative regulation to be implemented. For example, the exemption from luxury good tax require regulation at the ministerial level and the government provincial. Meanwhile, for now, there are few derivative regulations that support the beef, like Jakarta Governor and the Bali Governor. More technical or derivative regulation needs to be formed immediately to welcoming the 2025 target. For the next slide, will be explained by Rahma Chandrika. Rahma.
Thank you very much, Bayu. Of course, we cannot proceed into talking about the development of electric vehicles without considering the infrastructure that goes with battery-based electric vehicles. The adoption of electric vehicles demands complementary services in order to maintain the electric vehicles themselves. Therefore, it is important to ensure that there is a complete and supported infrastructure in order to develop electric vehicles. The infrastructure that generates from applying electric vehicles into the market is the readiness of building charging stations, road infrastructures, as well as smart grids to support electric vehicles. It is revealed that other than expensive price and driving range, not having enough access to charging stations is a major barrier for consumers to purchase electric vehicles. This is also a major drawback for Indonesia, which has targeted its electric vehicles output will reach to 20% of total vehicle production by 2025. The fact is that conventional vehicles run because of fossil fuels, whilst electric vehicles run because of battery. Consequently, there needs to be an appropriate amount of charging stations in order to make the electric vehicles run. There are several issues about having battery to run electric vehicles, such as limited distance, battery prices that are costly, and it is inconvenient due to the battery charging is relatively long. Having that in mind, electric suppliers would need to foresee the long-term investments needed to respond to the global trend of electric vehicles. Other than the battery issue, there is also a smart grid issue for the maintenance of electric vehicles. A smart grid is an electricity network that includes a suite of information, communication, and other advanced technologies for the control and management of transport of electricity from all generation sources to meet the varying demands of electricity consumers. Smart grid systems for battery charging stations and fleet management system also require more funds to maintain and manage. Applying smart grids it can be said that it is an essential part for electric vehicles because coordinated charging is the most appropriate and valuable strategy for electric vehicles network owners and operators. In conclusion, charging stations and related infrastructure remain a challenge because the concentration or enthusiasm of the electric market is still not too high amongst the Indonesian citizens. Next. The Indonesian government needs to constantly be reminded that diverting demand from fuel to electricity will create a major increase in the electricity demand on a large scale. However, there are several progresses because in March 2019, Minister of Finance Sri Mulyani Indrawati declared a new luxury tax scheme designed to encourage production of greener cars. And the plan also includes removing luxury tax completely for electric vehicles and a low rate for hybrid cars. And it is also explained that the Indonesian government, through the State Electricity Company or PLN, provides attractive offers for consumers who want to add electricity powers to their homes. Through this program, the government provides discounts for customers who will make additional electrical power ranging from 220 volt ampere to 197 kilovolt ampere. The discount categories are ranging from 50% to 100%. And this is a non-public infrastructure facility in order to develop the future of electric cars in Indonesia. Moreover, PLN as a state-owned electricity producer has prepared public electric vehicle charging stations at several points in Jakarta. These charging stations has also been extended to Bandung and South Tangerang. In its statement, PLN actually said that that they are confident to build infrastructure and provide electricity supply for electric cars because PLN has experience providing electricity facilities for mass transportation of electric trains. Thus, this makes PLN have more commitment towards the electric vehicles program. From this explanation, we conclude that next. We conclude that the legal framework for developing battery-based electric vehicles in Indonesia already exists and is well mapped. However, there are problems in incentive policies that make it difficult to form a BEV business ecosystem shortly due to first, lack of incentives for consumers, lack of control over conventional vehicles. There's also still need of various technical regulations or regional government regulations to support the presidential regulation on BEV. Besides that, the second problem is related to the BEV infrastructure. With the national target of production in 2020 and market share in 2025, there are still many BEV infrastructures in Indonesia that have not been truly developed, such as charging stations, road infrastructure, and smart grids. Next. Hence, we suggest that we suggest that in terms of regulation, the central government should refine the presidential regulation on BEV and immediately form technical regulations such as regulations at the ministerial level and also provincial regulations. From an infrastructure perspective, the government must immediately also focus on encouraging the development of BEV infrastructure in Indonesia, especially in industrial-based provinces. Lastly, Indonesia needs to do more research to know the obstacles to the development of electric vehicles and how to overcome them. Because Indonesia is not a country that fully supports research development compared to other countries in the ASEAN region. Therefore, research is needed and it is crucial for infrastructure arrangements and a substantial incentive policy. That is all from me and Bayu today. I hope the material that we have given could really reflect and update the audience about the development of electric vehicles in Indonesia currently. Thank you very much for coming.
Thank you, Rahma and Bayu. We already have some questions in the chat box, and I will maybe some of you can start to read that. But before we discuss the questions, let's move into the fourth speaker, Anissa Ayuning Teas. and she will talk about migrant worker remittance. Time is yours for 15 minutes, please.
Thank you so much, Madam. So, good afternoon, ladies and gentlemen. It's such a pleasure for me to see you there, and we hope you are all healthy and safe everywhere you are. So, before starting the presentation, I'd like to thank the committee as well as the moderator for giving me the opportunity to share our research with you today in this forum. And without any further ado, ladies and gentlemen, I and Dr. Mylinda Eka Yuniza are doing a research on the role of Indonesian government in managing the remittance of Indonesian migrant workers. So this actually talks about the intervention of government in the management of Indonesian migrant worker, how a government of a migrant worker state of origin intervene the migrant workers remittances management. And this is the outline of our presentation. So today we'd like to share with you the background, what is triggering our research, and then the questions raised in this research, the main findings, and the perspective for future works. Okay. And then for the background, ladies and gentlemen, this research is triggered by a provision within the newest law on the protection of Indonesian migrant workers, the law number 18 of 2017, as it imposes an obligation for Indonesian government to give an economic protection to through remittance management. So on the left side, you can see the exact formulation of the article. Both the central and local governments, in accordance with their authorities, are obliged to conduct economic protection towards Indonesian migrant workers and or the potential Indonesian migrant workers through remittance management by involving banks or non-bank financial institutions within the state and the placement state. However, um, there are some circumstances to be considered in regards to the applicability of this new provision. If we compare this provision with the previous formulations of government intervention in Indonesian context, the government intervention on Indonesian migrant workers' remittances has actually occurred since the 1983. So there was a ministerial decree in the 1983 obligating Indonesia to set aside at least 50% of their income to send to their families through the government's bank. And then the form of government intervention changes into remittance program, and then monitoring, and then this is the last one. If you compare this new provision with the previous formulations of government intervention, this article actually shows disparate nuance as it is placed under the framework of economic protection. However, there are some circumstances to be considered in regards to the applicability. The first one is the law number 18 of 2017 itself neither provide any further provision in another article nor any explanation in its elucidation. Second, there is a legal vacuum due to the absence of implementing regulations, so there should be a government regulation further regulating this government intervention on Indonesian migrant workers remittances, but and it should be stipulated since by the end of 2019, but they're still not implementing regulation up until now. And the third one, migrant workers remittances impact for the state of origin is actually conditional, even though most authorities in the state of origin seem confident that it is 100% positive, but it actually depends under specific circumstances under which such migration occur, as well as the general economic and political condition within the state. And the last one, and most importantly, migrant workers remittance is essentially a private transfer. So how can the government touch this? Because migrant workers remittances is actually sent by a member of family who work abroad to their families within the state. So the state is actually just bypassed as a consequence that the remittance receivers are within the jurisdiction of the state. Okay, so as the new law obliges Indonesian government to give economic protection through remittance management, while the migrant workers remittance itself are attached with aforementioned limitation and conditionality, it is important to make sure whether such management is justified, and if it is yes, it is important to stick to what extent it should be conducted. Hence, these are the research questions raised in this research. The first one is government obligation to conduct economic protection through remittance management justified under current Indonesian legal system. And the second one, to what extent Indonesian government is enabled to intervene the management of Indonesian migrant workers' remittances. From those research questions, there are two main findings we'd like to share with you today. So the first one is about the justification. In the justification, as a private transfer, migrant workers' remittance is actually a component of secondary income in the balance of payment that can be included in the national income calculation. But in Indonesian statutory laws, national income is an economic concept unidentified therein. Neither national income nor other terminologies equal to it have found to be regulated. We might see some terminologies that might seem similar, such as state finance, state income, state revenue, state asset, but these are actually incomparable to national income as these terminologies count heavily on state as the right holder and or the duty bearer. Even in the 1945 Constitution, containing a specific chapter on national economic and social welfare, the concept of national income is not indicated. However, this is probably due to the economic provisions within the 1945 Constitution itself that are still insufficient, including how state intervention on economic resources allocation is merely covers natural resources and important sectors of production in the Constitution, while Indonesian migrant workers is actually a human resources as a part of economic resources, uh, and they are actually the one who produce the remittance, but the provision in the Constitution itself regarding the state intervention on economic resources allocation do not cover human resources. So within this condition, the most plausible justification is that Indonesia is a welfare state aiming to improve general welfare and underlying on the principle of social justice. However, the absence of provision on state intervention on human resources is still an obstacle. If we look at the 1945 Constitution, indeed, human resources are granted human rights. For instance, the right to work and the right to receive fair remuneration. However, in a welfare state cannot be understood just in terms of human rights entitlement. Human rights entitlement is a matter, but how state activities interlock with market must also be taken into account. And the second obstacle is that international labor migration, the activity producing Indonesian migrant workers' remittances, intrudes on and challenges the endogenous nature of a welfare state. Why? Because a welfare state is by their nature meant to be a host system. Uh, well, in terms of Indonesian migrant workers, the state deployed it workers outside the state. They deploy their workers overseas to produce the remittance. Okay. Due to the lack of state intervention provision on economic resources allocation within the Constitution, the Indonesian migrant workers' deployment abroad as a form of government intervention on human resources actually lacks a constitutional basis. However, in the Republika era, the number of Indonesian migrant workers to be deployed were explicitly targeted and it increased annually. And second one, the specific chapter on the balance of payment recorded Indonesian migrant workers' remittances as a component of net factor income, included workers' deployment abroad as a means to increase foreign exchange income sourced from remittance, and estimated the amount of foreign exchange income from remittance. These are actually no longer visible in the regime of RPJMN, but the need of opportunity to work overseas are still realized due to the huge amount of employment within the state, and the contribution of Indonesian migrant workers' remittances on foreign exchange is still acknowledged. Well, in relation to the concept of democracy and constitutionalism, a welfare state's government intervention is allowed only if it is approved by the people, meaning that it should emerge at least at the legislation level. Meanwhile, Repulita is at the level of presidential decree and FPJMN is at the level of presidential regulation. So, in consequence, Indonesian migrant workers' deployment abroad has only been justified since the 1997 through the inclusion of government as a party that can do worker placement within the law number 25 of 1997 on manpower. Similarly, government intervention on Indonesian migrant workers' remittances has also been justified through its inclusion within the law number 18 of 2017. So the second finding is about the restriction. So although the Article 35.8 of Law Number 18 of 2017 itself appears as the justification for the government intervention on Indonesian migrant workers' remittances, the fact that Indonesian migrant workers' remittances are private transfer and it does not fall within the scope of state finance, and that the Constitution provisions of state intervention do not cover human resources, these are the facts that becomes a forceful impetus to restrict Indonesian government in intervening the remittance management. And in this research, we found there are three types of restriction. The first one, the natural restriction. So government intervention on Indonesian migrant workers' remittances is naturally restricted by the private nature of migrant workers, and it leads to the stages of remittance management. The government may intervene as well as the degree of accessibility. In a sense, uh, there is no stages of migrant workers' remittances management wherein the government has the full and direct access, and the widest scope for the government is merely at the transfer process as 100% remittances exist in the transfer process. Meanwhile, spending allocation it is logically a restricted area as it is fully controlled by migrant workers' families, and it can only be stripped toward investment and entrepreneurship through education. And when remittance management is allocated to investment and entrepreneurship, it is no longer 100% of remittance, but it's less than 100%. However, if we look at the intake formulation of Article 35 of Law Number 18 of 2017, investment, financial and entrepreneurship educations are steps excluded from the remittance management. The second one, the technical restriction. So government intervention is also restricted by the relation between Indonesian government and the institutions relevant to Indonesian migrant workers remittance management. There are actually many institutions related to the management, but the article formulation focuses on banks and non-bank financial institutions. Okay, so the technical restriction will be the relation between Indonesian government with banks and non-bank financial institution. Both these institutions are state-owned or private-owned, whether these institutions are in Indonesia or in the placement states. And the last restriction is the ultimate restriction. So the placement of government intervention within the framework of economic protection ultimately restricts the government intervention on Indonesian migrant workers' remittances management, so it has to be conducted with the intention to give economic protection. Government intervention on Indonesian migrant workers' remittances must be a means of protection, but job creation within the state, in the context of Indonesian migrant workers related to the concept of welfare state as a closed system, appears to be the best way to protect Indonesian migrant workers while reducing the dependence of Indonesia on labor migration. This can be an attempt to blunt the sharp disparate condition for the sake of maintaining the welfare state concept in an increasingly interdependent global political economy. Indonesian policy in terms of government intervention on Indonesian migrant workers' remittances will be a safe house if the general economic condition within the state, including the job creation, is also enhanced. And the last one, ladies and gentlemen, this is still an initial research in understanding the role of Indonesian government in managing the remittance of Indonesian migrant workers, as this research still sticks for the justification and restriction for the government intervention. Of course, we admit that you might find some loopholes or something, and we still need to improve this research. But for a more comprehensive understanding, more complex, more implementative research is also needed. So we also need to seek the relation between the central and local governments in regards to Indonesian migrant workers remittances, and we also have to clarify the technical restriction how the relation between Indonesian government with banks and non-bank financial institutions within the state and the placement state, both state-owned and private-owned. So I think that's all from our team, Mbak Arum. That's all the presentation. Thank you for your attention.
Thank you, Anissa. So thank you all for the presentations. Now we are moving into the question and answer session, and we have approximately 1 hour to discuss. We already have some questions, but for the participants in the Zoom meeting, please raise your hand if you have more questions, so I can go to you after delivering these questions. So I'll read some of the questions first. This is the question from Dedi Kristanto, and I will give this question to Bayu and Rahma because it's related. So the question is, there are two questions from Dedi. The first one is, did the political interest of the Jokowi regime not hamper the production's process of laws and regulations at all? It must be admitted that until now, this field is very attractive to many groups, including parties, companies, and even countries, to be able to control the energy supply and demand pathway, and so on. And the second question, what is the big hole in all of the laws and regulations product related to energy, electricity, and natural resources that will harm the lives of the Indonesian people in general? And then the second question, I think it will be more suitable to be answered by Bu Mailinda and Melody. The question from Ferdinand. I think there are 2 or 3 questions in this whole paragraph. Let me read it. How the simplifications of license applications by online can be used as the lever to reduce climate change issues. Thus, every license applications filled by oil and gas companies also reviewed by the Ministry of Environment and Forestry. Is there any system for collaborations between Ministry of Energy and Mineral Resources and Ministry of Environment and Forestry? Because as we all know, there are lots of laws and regulations related between oil and gas and environment. And then the third question will be addressed to Anissa. There are 2 questions. The first one, what benefit would be better given by the government to the migrant worker? Perhaps special exchange rate or anything else? And then the second one, do we need to give different benefit or treatment? And we means the government. Do the government need to give different benefit or treatment for the blue collar migrant and the white collar migrant? I think we have one more questions. It's a follow-up questions from Dedi Kristanto. You can also read it on the chat book. I read it. My question relates to the research on remittance from IMWs for Anissa. Yeah? The first one, from the point of view of laws and regulations, how do the governments and other actors and agencies view Indonesian migrant workers? Are migrant workers only seen as a generators of remittance and mere commodities, or are they truly human? Second question, has state of government intervention so far, sorry, I repeat, has state or government intervention so far been sufficient to place Indonesian migrant worker as a group that is valued enough because their economic contribution to Indonesia is very significant? What laws and regulations are really needed to protect Indonesian migrant worker? So um, well, you can start to deliberate your answer. And I also want to highlight this is the issue that maybe all of the participants could also take this note to raise more questions. That all we know is one big issues in developing countries, including Indonesia, when we deal with when we deal with development, infrastructure, and energy, one big issue that still need to be addressed is environment. So how would you deal, or sorry, how would you see how the government deal with environment issues when dealing with energy infrastructure development? In your research, do you see how this balancings of the needs of energy and infrastructure development and also environment in the other hand? So I think we while waiting for other questions, if we have, maybe we can start the answer sessions, starting from whoever want to answer it.
If I may, can I answer the first questions about the political interest of Jokowi regime towards the electric vehicles? Thank you very
Yes.
much. So, the question was, did the political interest of the Jokowi regime not hamper the production process of laws and regulations at all? Because the electric vehicles industry is actually still very attractive to many groups. So to answer that, of course, to some extent, the political interest of the Jokowi regime has affected and hamper the production process of laws and regulations, because as we have concluded that and we suggested that we see that there needs to be more technical derivative regulations towards the electric vehicles, and the synchronization between the ministerial and the government and also the provinces regulations are also have lack of synchronization. So, however, from what we see is that from what we have researched, the Indonesian government is actually very ambitious towards the electric vehicles because because in October 2019, there are bilateral relations between Indonesia and Germany, that will continue to strengthen the two countries' automotive industries on electric vehicle production. So Indonesia also expects real action from Germany, especially in the form of direct investment. So, considering the fact that the Ministry of Finance also is planning a scheme where they want to remove a luxury tax scheme for electric vehicles, and then there's this news about the electric vehicle cooperation between Germany and Indonesia. It can be seen that the Indonesian government or the Joko regime is actually very ambitious towards the electric vehicles production. So because I think they also acknowledge that it is still a very attractive market for a lot of people in Indonesia, considering that how fossil fuels or conventional vehicles create pollution. So so I think despite the political interest that hamper the lack of laws and regulation, Joko regime is also working through a lot of scenarios to increase the production of electric vehicles. So to conclude, there is a hamper from the Joko regime. However, I think they are being quite ambitious to have a progress and also reach their target of total production vehicles, electric vehicle total production of 20% in 2025. So I think I can answer that. And For the second answer, I'm gonna give it to my co-author, Bayu. Bayu, you may answer.
Okay, thank you, Rama. The question number two is about the big hole in all the laws and regulation product related to the energy, electricity, and natural resources that will harm the lives and of the Indonesian people in general. As I mentioned before, that in our study, there are three main laws that regulates about the energy, regarding to the energy, electricity, and natural resources like the energy law, the government regulation on conservation energy, and the government regulation on energy policy, national energy policy. And uh, among the three law, we found that the big problem is the inconsistency between the vision in the energy law, for example, between the energy law and then the government regulation. And if we referring to the energy law, actually the government national energy policy, actually there are already awareness about the balancing in economic concern and then environmental concern. But and then in the implementation, the Jokowi government then keep forced to producing the energy, the electricity based on coal mining. That means the pembangkit listrik tenaga batubara, the PLTB. It is mean there are no inconsistency between the legislative between the legislative and the executive. And the second inconsistency that we found that is between the one uh, one one regulation and in another regulation, like the government regulation on the conservation energy. If we're comparing to the BEV regulation, the presidential regulation, in the conservation, in the government regulation of conservation energy, is clearly already regulates this diversification of energy and conservation of energy to provide energy reservation. But in the BEV presidential regulation, some of the provision in the government regulation that is not regulate anymore, like the disincentive that we mentioned as we mentioned before. And what the impact? The impact is first the our energy reservation is remains low, and then uh, we dependence into the coal industry or coal mining, and then yeah, it is will impacting the implication more is about the environmental issue and then the environmental license like that. I think that's for me. Thank you.
Thank you, Rahma and Bayu. So, Ibu Mailinda, would you answer the question,
Okay,
please?
thank you very much, Harun. So, yes, I agree with Rahma and what Bayu said previously. So, if I look at the first questions, yeah, we cannot deny that regulation is a political product. So, talk about law concerning energy, it can be said that this field is one of the most vulnerable areas to conflict of interest, including investor interest, which is pushed through the government. So, I will not go deeper to politics, but however, there are like several law, draft law, which now issued or almost issued by the government, the Jokowi government, which are highly criticized because of the content of the law itself. So, for example, we have law on Minerba, and then we also have the draft law of Omnibus Law Ciptaker, which is believed that it's not populist at all. And then we also have the drafted like oil and gas law, which is now no longer in the priorities to be enacted. If we look at the urgency of this law, it's very urgent, particularly after the constitutional court law dismissed several like important article of the law, but then it's now not becoming the priorities to be drafted. Um, because there is like a very huge conflict of interest regards to the law. So from this condition, we can see how the politics is like influencing, have a very huge influence to the law or regulations in and Indonesia. And then the second questions regarding the big hole, as in the other fields related to the energy law, we still have problems with overlapping regulations. On the one hand, we have like inconsistent regulations, particularly from the higher regulations to the lower regulations. And uh, we also have the problems with the government, which again inconsistent making regulation. For example, just lately the government switched back the contract of oil and gas from gross split back to the normal PSC atau or production sharing contract. After it just like 2 or 3 years ago, we applied the gross split contract. So the government, they don't really consistent in applying the law. So there's like questions regarding certainty from the investor, from the people, what is actually the blueprint of the government related to the energy law. We also have problems with like over-regulated in one hand and also less regulated in the other hand. What is I think important to be done by the government is not only making the blueprints in energy fields, but also the government need to evaluate the compliance or suitability of the existing regulations to make sure that the existing regulation is going to the right path or the right way to achieve the blueprint. And then the other question number 3, related to the permits. Um, I believe that the government, they uh, try their serious effort to make the to simplify permits in energy field. In upstream oil and gas, I know that SKK is doing this task. They coordinate with BKPM, Badan Koordinasi Penanaman Modal, as the institution which has the authority to perform OSS to simplify the permits in the upstream oil and gas law, oil and gas. They also coordinating with the Ministry of the Environment, of course, and also the other ministries of Marine Affairs, and etc. But again, it's not that easy to balance the interest. We know that the key is we have to what is it? We have to maintain, we have to hold, we have to keep the environmental, the interest of the environment, it should be kept, but we also make sure, we have to make sure that the permit is simple, fast, and also certain, so that the business entities are attracted to be involved. However, again, it's not easy to balancing all of these things to keep the environmental still like safe, but in the uh, other hand, we make sure that the process is fast, the process is certain, and also clear for the investor. So there's still a homework for the government regarding that issue. So that's it, Arum, I think. Thank you.
Thank you, Ibu Mailinda. Melody, please, the
Yes,
floor is on.
I little bit add Melinda answers. So, in fact, licensing simplification aims to simplify and centralize licensing, which is directly regulated by the central government. In state administration, uniformity is something that can facilitate the way for licensing. But the problem is, what if there are steps in environmental licensing that are reduced or eliminated? This is still a conflict, but in the omnibus bill says that there are differences in licensing based on the risk of each infrastructure development. Again, I think the government must choose what will serve as the country's goals. And however, the environment and the economic and society must remain vigilant and be accommodated in balanced manner. And for the electricity sector, the government has planned to reduce the use of petroleum and also the use of coal for steam power generation through the use of more environmentally friendly energy, for example, use of LNG as a commitment to enter into Paris Agreement. And for the second question about the there is internal cooperation in form of memorandum of understanding between the Ministry of Environment and Forestry and the Ministry of Energy and Mineral Resources. And the memorandum of understanding also covers the scope of monitoring, the handling of problems, and law enforcement, controlling small-scale mining, especially gold, which has also been initiated into certain areas with business transformation to be pushed into social forestry scams. So that's it. Maybe can answer Ferdinando's credo question. Thank you.
Thank you, Melody. Anissa, please have yours.
Yep, thank
Anissa,
you, Baron. So thank you for the questions. This is all of these are good questions. So I think I'd like to answer. mm, okay, in regards to the excuse me. Okay. So from the point of view of laws and regulation, how do the government and other actors and agencies view Indonesian migrant workers? Are they are migrant workers only seen as generators of remittance and merely commodities, or they are truly human? This is very interesting because we found that uh, in the sixth Repelita, the government even mentioned Indonesian migrant workers' deployment abroad as an export of service. So, and this is what we afraid of the absence of state intervention provision in the Constitution. State intervention on human resources allocation. That the first one, the action itself is like a constitutional basis, and the second one, we also cannot find the extent to which the government may intervene these human resources. That is what happened in the Repolita regime. So yes, migrant workers are considered as a commodities, I think. But the law on Indonesian migrant workers also changed over time, and I think the newest law, the 2017 law on the protection of Indonesian migrant workers, is pretty much better than the previous one, as it already strayed towards the protection aspect instead of placement aspect, like what the previous laws is highly criticized. So that's my answer for the first questions. And then, has the state or government intervention so far been sufficient to place Indonesian migrant workers as a group that is valued enough? Okay. So unfortunately, it's kind of difficult to conclude whether the government intervention has placed Indonesian migrant workers as a group that is valued enough for their contribution, because there are so many news, and we can see it up until now, on how migrant workers are, I don't know, uh, involved like in the crime, in the criminal activity, and sometimes they become the victim of uh, violence. So uh, the law is already give like a legal protection, social protection, and economic protection in the U.S. law, in the law number 18 of 2017. But I don't know whether it is already implemented uh, well, because yeah, there are still, we can still see the news, the bad news on migrant workers. So, and then about the what benefit would be better for migrant workers. So actually, there are many examples given by the other states. For instance, uh, foreign currency, not a repatriable foreign currency account. So the other state provide accounts specified for migrant workers, wherein the accounts is not subject to foreign income regulation. And then there is also foreign currency denominated bonds that also beneficial for migrant workers actually. And for instance, in the investment stage, Pakistan has non-reportable investment scheme, and Pakistan allowed its migrant workers to invest in export processing zones with complete duty exemption. And another example given by India, India give their migrant workers preferential access to capital goods. And then Thailand also give another example. There is advisory services and supplementary loans for investment for the migrant workers. But again, whether this can be applied in Indonesian context is depends on how Indonesian government relate with the institutions related with this kind of management. So yeah, I think that is my answer. But Arun, is there any questions that have not been answered?
Yeah, I think that's all good. Thank you, Anissa. So
Yep.
we still have 30 minutes for discussion. So if anyone wants to raise question, please you may do so. Or if not, I still have some written commands or questions to be discussed. Please. Right. So let me read some of the questions now. Um, I think this is for the first presenter, Bu Mailinda. You've discussed on the one price oil policy throughout Indonesia, and you've explained that actually there are different costs, different distribution costs actually when we want to sell it in Java and in Papua, for example. So, um, is there any potential loss of the profit in the case of one price oil policy? If so, then how to cover this distribution cost loss by having the one price oil policy? Because of course we know the one price oil policy is to reduce the price of the oil in Papua, not to increase the price of oil in Java. So there will be some loss there. And I, I'm interested to know how the state-owned enterprise doing business. Is there any difference on the profit orientations compared to private companies, for example? Because this is state-owned companies, so the state-owned company will not um, emphasize more on the profit, and it's okay for them to not have profit, but more on the service for the society, or how is it? How should we see the framework of the state-owned companies on doing business? And then um, this is interesting. The third presentations from Bayu and Rahma, when you actually there's a doubt in the government incentive. So and you did mention that somehow the incentive is given to the production more, not the consumer. So the question, if even if the incentive is given to the consumer, don't you think that the subsidy or incentive, the government's money, the state money, will be given to the rich instead of the poor? Because who can afford to have, let's say, electric car or vehicle? Of course, because of the price, it's still high. So if the government give incentive to the consumer, to those who can buy these vehicles, of course it will be given to the rich. Or is there any a framework, or is there any way of this policy that giving the idea is on distributive justice, whether the policy of the government is also beneficial for the poor or for the common people and not only for the rich? So how do you see that? Okay, who want to start to answer that?
Okay. I'm trying to answer the questions. So thank you, Arum. Yes. So before the one price oil policy launched by the government, there is a like huge gap, like I said previously, between price of oil in Java and then the eastern part of Indonesia because of the expensive cost for the transportation or the distributions. Um, so by applying this one price oil policy, the government, they trying to first the government, they, what is it, delayed the subsidized for oil and gas, but then they also cooperate with the BUMN, state owned companies, under the public services obligations of the state-owned companies. So the state-owned companies, they have like two major duty. The first one is giving like public services or service the public services, and then the second one, making like profit or benefits from their business. Now, uh, under the public services obligations, the state-owned company, they the government can give like a special um, duty to the state-owned company, including in distributing the oil to the eastern part of the Indonesia. And then previously, they take benefit, or they taking the price from the distribution cost for the transportations, but then now they cannot do that by applying the public service obligations. The government, they making the minimum and also the maximum formal price for the distributors. They subsidize it for the transportation cost, and therefore the similar price in Java and Papua could be happen. So yes, there is a like different way in doing business between the uh, state-owned companies and also the pure like private companies. The government, they can giving like special tasks to the state-owned companies under the public service obligations. Is that answer your questions?
Yes, thank you, Bu Mailinda.
Okay, thank you, Arun.
So Bayu or Rahma, do you have any
Okay.
comment?
If I may
Yeah.
start to answer your questions, thank you very much for the question. I think that is one of the highlights for from our paper too. One major drawback from one major drawback for Indonesia to produce the electric vehicles is because electric vehicles are still luxury goods. They can only be purchased at least from upper middle class. So it is therefore we stated that there is a certain doubt from the government because it is quite impossible to completely exempt ourselves from having or operating our conventional vehicles to electrical vehicles, especially the lower middle class. So I think the one of the ways to navigate that from the government was that I think the government is planning to exempt. There is a plan for exemption from luxury goods tax and vehicle transfer fee tax, but it still requires regulations at the ministerial level as well as at the regional level. And also, as I have previously mentioned before, there is a plan from the Minister of Finance, Mrs. Sri Mulyani Indrawati, that she declared that she is planning to removing luxury tax completely for electric vehicles and a low rate for hybrid cars. So this is to encourage the production of greener cars and also to reduce the pollution from the conventional vehicles. I think my co-author would like to add something to answer to this question.
Uh, I addressing from another perspective. Uh, yes, thank you, Rahma. I agree with that. And then uh, basically the question of Mbak Arun is what kind of model of incentive like Indonesia will do if incentive is exist in Indonesia, as I mentioned before. I think a good model is yes, it is selected by the government. Uh, it means the government makes a mechanism regarding certain specification for the production or for the sales for the cars, and then the specification for the people who want to buy and want to have an incentive. there will be a selected mechanism for by the government. But in essence, the point is this cutting price incentive must exist because to reducing prices in the real terms. I mean, in the real perspective. But psychologically, this will affect the desire of buyer to buy it. If there is a discount, if there is a cutting price, psychologically the people will more desire to buy it. So everyone wants a discount. I think this is in the marketing world. I think this is a kind of promotion that will government must to do in the incentive policy. Thank you.
Thank you, Bayu and Rahma.
If
So
if
there is,
I might add to Bayu and Rahma.
please.
Okay, so Arum, I and also Rahma and Bayu and also the others like participants, correct me if I'm wrong. I think the discussion regarding the BEV is not yet finished among the government itself and the government and also the local government because like uh, like Bayu said previously, the price of the BEV is still high, um, and also the capacity of the people to buy it is quite low, and the government is still thinking whether to push like BEV as a best choices in these right now conditions because if we look at the electricity itself in Indonesia, one of the benefit of using the BEV is because of the green technology. It can reduce emission and etc. But also it's important to look how the electricity itself is produced. Like what Melodia said previously, in Indonesia, electricity is still produced mostly from the fossil fuel. So it's still the problem by itself because the electricity itself should be produced uh, ideally from the using the green technology also. But if the electricity is still using the fossil fuel, then it's not really green, even though the BEV itself using the electricity. So that's one of the point. And then the other points, we know that tax is still, what is it, the main um, source for Indonesia to, you know, for the like our as the source of our finance, our national finance. So is it giving the incentive for the BEV, is it the best choices for the government, and compared to the effect of the BEV, if it's really like supported by the government. So there's like several discussions around regarding the BEV, and then that's why the title of the uh, what is it? The presentation itself is like the doubt regarding the government policy concerning BEV because it's not yet finished the discussions. Thank you.
Thank you, Bumailinda. So because of the time constraint, I think we move into the last sessions. I'll give each of the presenter probably 1 or 2 minutes to have a concluding thought on the issues of legal development in Indonesia, on energy infrastructure and migrant workers. So perhaps you could conclude it and reflect it, compare it distributive justice, perhaps, or the balancing of these issues with environmental issues. So, who want to start first on your conclusion or personal reflection start? Let's start with Anissa first, please.
Okay, thank you, Wan. So I think for this issue contribution to legal development is that we already knew that the law, the constitution itself, is still lack of a provision on the state intervention on economic resources allocation, as our constitution is still very conventional on that. It merely covers the natural resources and important sectors of production, while human resources should also be considered. So for the legal development, uh, I actually demand state intervention on human resources allocation to be also put in the constitution, because this is very important, especially for the migrant workers, for Indonesian migrant workers, to um, protect them, to restrict the government intervention on them. I think that's from me, madam.
Thank you. We have one more comment on the chat, but or maybe I'll read it now before moving to the other speaker. This is from Dedi Kristanto. He said, based on my research on among Indonesian migrant workers in Hong Kong, remittance is also a struggle for money transfer providers only. The government established three state-owned banks in Hong Kong, namely Mandiri, BMI, and BRI, to serve the money transfer process. The point is clear that money sent by migrant workers to the families in Indonesia can flow to Indonesia and not to other countries. But it is unfortunate that this education on financial delivery is far from being roasted than fire. Many migrant workers are still not properly taught how the remittance mechanism can benefit them. So I'll read it because it related to Anisa's research as well. That could be one of the leftover comment that we haven't discussed yet, but let it be our reflections on that. So now let's move into the issues of energy. So Bayu and Rahma, who wants to speak first on your conclusion?
Okay, in conclusion, I think production of electric vehicles is a very feasible idea towards a more environmentally friendly world or like situation in Indonesia, because as we know, conventional vehicles contributes a lot of pollution, and it does impact severe health impacts. And I think it is also in order to fulfill the UNDP goals about of being a state which upholds environmental friendly substances and also vehicles such as electric vehicles. And I think the development of electric vehicles in Indonesia can be further improved and further enhanced. And I do not lose hope that Indonesia could achieve its targets in 2025 if the government is really willing to do so, especially considering the fact that Indonesia and Germany are trying to cooperate with each other towards the future production of electric vehicles in Indonesia. So I think there is a bright future ahead, but however, the government needs to stand up, needs to reevaluate the regulations and the policies that they are trying to make. I think my co-author would like to add something. Bayu?
Okay, for me, thank you, Rama. For me, the BEEF program, yes, just the BEEF program can be related in many sectors, such as environmental issue, economic issue, industry, and energy. And then it is important to think holistically about the legal framework because it will have many implications in the many sectors. As Bu Melinda mentioned before, that the BEEF discussion has not been completely yet, and until 2025, the government must continue to follow up this BEV program. Thank you.
Thank you, Bayu and Rahma. Melody?
Thank you. So technological development are accompanied by hopes for a more environmentally friendly energy infrastructure. The government policy in the form of the 35,000 megawatt of electricity has encouraged the use of LNG as a cheap and environmentally friendly energy source. However, there are steps that must be taken, namely the development of electrical energy infrastructure in form of LNG power plant construction or LNG production itself, which of course needs to be accompanied by licensing. Based on this research, I emphasize that the role of the relevant ministries and regional heads, PT Pertamina, PT PLN, is very important, uh, especially in licensing to encourage the presence of LNG, which can be one of the main source of electric energy in Indonesia, and that is environmentally friendly. Thank you.
Thank you, Melody. Ibu Mailinda.
Okay. Thank you, Arum. So, as my closing statement, I think there's still like huge homework for the government to sufficiently interfere the development of energy law. One of the like important keys in every policy taken by the government is they have to make sure a balance between environmental protection and also development interest. Thank you.
Thank you all. So it was great time meeting you and discuss these interesting issues with you. And unfortunately, time is limited as always. So we have to end these sessions, but the conference still have more sessions, and you can either join the Zoom meeting like this or following us on the YouTube live. And I thank all of the presenters and also the participants for making these sessions awesome. And I'm sorry for any mistake and any bad things happened during these sessions. And have a good day, and I'll see you soon. Thank you so much, all. Bye bye.
Thank you very much.
Thank you.